everyone, welcome back to my channel. My name is Meenakshi and I am doing a video series on the Indian Constitution. Apart from discussing the articles or the main concepts, we are also discussing some of the landmark cases that will help you understand the concepts even better. In today's video, we are going to discuss a landmark case relating to Articles 14 and 21 of the Constitution. It's Maneka Gandhi versus Union of India 1978. Before moving ahead with the facts of this case, let's see a little bit of history regarding this case. Under the Passport Act 1967, passport authorities are given this power or authority that they can impound passport of a certain person if that is considered to be essential in the interest of sovereignty and integrity of India, security of India, friendly relations of India with any other foreign country or general public. Impound passport as in passport authorities can seize and take legal possession of the passport for a certain duration of time. Otherwise, whenever the passport authorities are impounding a passport of a certain individual, it's necessary that they communicate about the reasons to the person whose passport is being seized by them. But in the interest of general public, disclosure of these reasons may be withheld by the passport authorities. So in this present case, a notice was issued to Maneka Gandhi, a journalist by profession, on 4th of July 1977 regarding impoundment of her passport. After receiving this notice, Maneka Gandhi wrote back to the passport authorities seeking disclosure of reasons based on which they are proposing to seize her passport. But the passport authorities refused to disclose the reasons in the interest of general public. As a result, the petitioner, Maneka Gandhi, had to file a writ petition under Article 32 of the Constitution of India in the Supreme Court of India. This writ was filed for enforcement of Article 14, seeking protection against arbitrary action of the authorities. Article 21, seeking protection of life and personal liberty. Article 19, Clause 1, Clause A, seeking freedom of speech and expression. And under Article 19, Clause 1, Clause Z, seeking right to freedom of movement. And that the order of the passport authorities is void and is taking away Maneka Gandhi's right to a free hearing and is taking away Maneka Gandhi's right to a fair hearing and to present her defense. In this case, it was held that the court should see that any procedure established by law do not suffer with the problem of unreasonableness and arbitrariness. Any such procedure should be just, reasonable and fair. In this case, court also held that the term personal liberty under Article 21 has to be understood in a broader and liberal sense. Therefore, Article 21 was given an expansive interpretation in this present case. The court in this present case obligated the future courts to expand the horizon of Article 21 to cover all fundamental rights and avoid construing it in a narrower sense. Court held that Section 10, Clause 3, Clause C of the Passport Act 1967 is violative of neither Article 21 nor Article 19, Clause 1, Clause A, nor Article 19, Clause 1, Clause Z, or Article 14 for that matter. Article 10, Clause 3, Clause C provides for an opportunity to be heard. Court held that Section 10, Clause 3, Clause C and 10, Clause 5 of the Passport Act is an administrative order, therefore open to challenges on the ground of being malified, unreasonable, denial of natural justice, etc. The court also suggested the government that whenever passport of a certain person is being seized by them, they should ordinarily provide for reasons for doing so. In this case, right to travel abroad was for the first time considered as a part of Article 21. So that's a very important point that you should keep in mind. We all know that the scope of Article 21 has been widened in many of the cases. We all know that the scope of Article 21 has been expanded in many of the landmark cases by the Supreme Court and also many other courts. So whenever you are answering a question regarding Article 21, Article 14, Article 19(1)(a), 19(1)(g), you can refer this case and you can mention that for the first time in this case, right to travel abroad was considered as a part and parcel of Article 21 of the Constitution. So that was all for this landmark case, Maneka Gandhi versus Union of India. I hope this case is clear to you. In case there are any more video suggestions, you can leave that in the comment section below. To see other videos relating to Indian Constitution, you can click on this playlist. To see videos relating to Indian Contract Act, you can click on this playlist. To see other videos relating to different topics of law, you can consider subscribing to the channel. Until we meet next time, bye-bye.